And you said try to go to a board meeting if it's going to be held at a time when it's coinciding with your review of the documents. But what other kinds of horror stories can you share with listeners so that they know, don't try this at home. Just do what you're told, because it's after this many years in real estate, I'm always surprised at how many people think that doesn't apply to them.
Absolutely. So it actually, I have a family member who lives in actually the community that I grew up in, who shared this story with me. They have a very simple set of rules in this particular community. Basically, it's make sure that your house faces the street when you're building the house, so it can't be sideways, and you have to have a split rail fence. At the front, at every part of your property, it has to be a split rail fence, anything that the community can see. Those are pretty much the only two rules in this entire community. And it turns out that one of the neighbors decided that she didn't want a split rail fence. She wanted a 6-foot wrought iron fence.
Oh my God.
So she didn't seek special permission from the board, and the board, of course, would have denied it because it was one of the two rules in this community. She built the wrought iron fence, and guess what? The board slapped her with a violation and required her to take down the fence. So she fought it for about 2 years, but ultimately she had to take down the fence. A lien was placed against her property. She said, I don't want the lien. And they said, well, take down the fence and put up a split rail fence. You'll be in compliance with the covenants. So really, this lady ended up spending a great deal of time and money first building the fence she wanted, and then having to pay to take it down, and then also have to pay for the violation lien that was placed against her property. And for what? It literally, all you needed to do was read the documents, and if she didn't like those rules, then it just wasn't the community for her.
It's always amazing to me that people don't. That's, to me, the documents are the most important aspect, and that's why I know the state that I'm in allows you to void the contract if you don't like something, rather than getting in on it and then finding out later. I had one where they were in an HOA and there weren't too many rules, but the house was sold, and the inspection process, during the process, they decided, get this, they did not like the color of the mulch that the owner had used. They used the red chip mulch instead of black, and they didn't like it. And they, believe it or not, they made them change it all out. So
wow,
petty things like that. And sometimes you get people who have nothing else to do except be on a board or work for an association, and that's what they love to, they love to be the police for the community. So it can get really crazy. And but now I know in some communities, if you don't fix something like you were talking about, over the years, fines can accrue. Is that pretty much the case if they find a violation and don't catch you, or do they pretty much give you a preferred time frame to be able to fix something before they slap a fine on you?
So typically they do give you some sort of a relatively reasonable period of time to fix it. And from my experience, for the most part, if the homeowner is truly acting in good faith and is trying to get the work done, even if it ends up taking a little bit of extra time, as long as they're explaining that to the community management and to the board, and they're showing documentation, they're showing proof that they're contacting contractors and that they're trying, most of the time, I mean, we're all people. We understand at the end of the day, the people that are on the board are typically your neighbors, and everybody wants to help each other out as a general rule. So, if the homeowner is really acting in good faith and trying, you're not going to have a violation immediately in most communities. But, as time goes on, patience wears thin. So you have to actually show that you're trying. And if you're not, then you're going to be subject to those fines. And typically those fines can be anywhere from 6 to 12 months of condo dues or homeowners association dues, plus whatever fees are required to actually get the work done. And depending on the violation, that could be relatively extensive and expensive.
Yeah, that's very true. And a good point. Thank you for sharing that. I had another question that came up when you are buying a new community. Let's say it's a condominium community and you're buying one of the units, but the builder hasn't completely sold out yet. So talk a little bit about, when does that transition from the builder maintaining it to having the condo have a board who then maintains it and hires their own condo association and a management company and that sort of thing. Talk a little bit about that. What is something that somebody should watch out for? Because if you have a bunch of board members who've never lived in a condo and then all of a sudden they have responsibility, that can get to be a challenge. And then at what point does the builder say, okay, I've sold, more than half or whatever his number is. Now it's your turn to take it over. Can you talk about that for a moment?
Yeah, so that's something that is definitely a good question for whatever new community that you're buying into. And when the builder decides to take that step back is really determined by the builder themselves. So in my experience, a lot of times in the area that I practice, they'll sell the entire building, and then the condo builder will take a step back anywhere from immediately after that last unit is sold. Sometimes it's turned over rather quickly within a couple of months to the new board and to the community management company. And sometimes it'll be the first year will be with the builder, and then after that it's transitioned over to the new owners. But something that I would look for in a new community or an existing community for that matter would be the parking situation, particularly with a condo. You want to make sure that are you actually buying a parking space or are you buying the right to use a parking space?
Right. Very important. Thanks for bringing that up. That's a very important point.
And especially with a brand new condo, you don't have that history like you do with an existing community. With an existing community, you can go back to the association and say, okay, in this particular condo unit, I have 2 parking spaces, and historically they've always been, let's say parking space 50 and 51. Has that ever changed? And there's a history to look back on for the past 10, 20, 30 years, and the people can say no, or only one time out of 200 units has that ever changed, something like that. With brand new construction, you might be guaranteed 2 spaces, but who gets to assign those spaces, and how will it be worked out in the future, and can those change? That can all be very important to your future resale value and just your regular use and enjoyment of your property.
Very much so. In fact, I've had condos where there were 2 assigned parking spaces in a garage, and the owner was a single person, and they wanted to find out if they could rent the other space. And this one particular condo association said, we don't care who parks there, but you have to take care of getting it rented and making sure nothing happens to any of the other cars who are not who are owners there. But so some people have made extra money. They can, $10,000, $20,000 a year just renting the extra space. But it is something that you need to check when you're buying into it too. So at the original, let's say it's a new condo building, who develops the actual association rules? Is it the builder, or do they assign do they hire an outside firm who comes in and does that for them? How does that sometimes work?
So obviously, at the end of the day, it's the builder who gets to come up with the governing documents, but they're always hiring an outside, they should be hiring an outside law firm, I should say. Right. And typically they do. And those are the people that actually file the restrictive covenants that the builder signs off on. So the very initial rules that govern the association, homeowners or condo association, come from the builder. And then if there's any subsequent rules after that, then that comes from the board and is then implemented by the community manager or the board themselves if they're self-managed.
So just to wrap up, I just have one quick question. On new associations, where it's a new building, in other words, does the board get any input? Are they allowed any input as to who the management company will be, or does the builder already go ahead and do that for them so they don't have to worry about it for the first year or so, and then they can choose somebody else if they don't like the quality of service they're getting?
So most of the time, the builder does go ahead and choose somebody just to help at the outset to make the transition a little bit easier. But absolutely, the board has a say after that. If they don't like the management quality, if they don't like the fees that the community manager is charging, they have a say. The board has a say in all of that to switch how they're managed. Because at the end of the day, it is the board that is implementing the rules, and it's the board with the power that can go to the community and have the community vote to change the actual declaration and the restrictions that the builder puts in place. So that sounds a little bit easier than it is in practice because it's very hard to get a large community to agree. So typically the rules that the builder puts out to start with are what the board follows, and perhaps they tailor that a little bit over time in practice. But changing the actual rules that are set out at the beginning can be very difficult. Possible, but difficult.
Well, yeah, and that we could do a whole session with you, Jessica, on just how to choose an association management company to manage, because there's good ones and there's bad ones. But we'll have to save that for another day because we're running out of time. But before we sign off, I want to thank you for joining me today. And if you could leave your email address and a website for people who need to get more information, even if they're outside of the jurisdictions where you operate, that would be a big help, because I think people really need to get all the information they can before they make a decision about moving to a condo or a homeowners association.
Absolutely. Well, thank you for having me. I really appreciate it. And the best way to get in touch with me is to visit our website, which is www.championtitle.com. And my email address is Jessica, Jessica, then the letter Y for last initial, at Case with a K, so it's KASE Lawyers, LAWYERS.com.
Well, thank you so much, Jessica. We will definitely have to have you back because this has been a very interesting topic, and I'm sure we'll get a lot of feedback. And if anybody has any questions for me, you can contact me at moveorimprove.with.debbie@gmail.com. And thank you so much, Jessica. It's been a very rewarding, informative 30 minutes.
Oh, thank you, Debbie.